This is very interesting because of the 16 cases that PLD monitored for purposes of this report, the findings are really findings that are in consonance with what practitioners of law like me usually encounter in courtrooms. I will concede that things have changed, and I will concede that our courts are far more sensitive today, and I'm speaking of Delhi, I'll come to courts outside Delhi later, than they were, say, 2 or 3 years ago. And many of these amendments have had an impact on the way a judicial officer takes control of these proceedings. Having said that, I think what the problematic area is when they try and balance the interests of a rape victim with the constitutional rights of an accused who also has the right to defend himself, and therefore, how do you do that balancing act? And that's where I think judicial officers sometimes falter. What is apparent from this report are two things at the stage of trial. One, this whole thing of attempting to conclude a rape trial in 2 months is completely unrealistic. I have long been an opponent of fast-track courts. I have long been an opponent of these short, fast trials because I don't think you ever end up giving justice to anybody. What happens is that there's bypass of procedures, everything is shortcut, the quality of evidence is compromised, and in the end you have some mishmash which really doesn't work. In any case, as this report very, very emphatically shows, not even the testimony of the survivor is completed within 2 months. And as Mrinal was telling me a little earlier, that I should probably say that it takes you see, the police has statutorily, the police is supposed to file the charge sheet within a particular period of time, 90 days. And if the accused is in custody, the police must file the charge sheet within 90 days or 60 days as the case may be. But, and if they fail to do so, the accused is entitled to statutory bail. By and large, the police keeps to that timeline. However, once the case comes to court, it far exceeds this 2-month period. And so therefore we need to relook at that, and should we even have a figure there that you must complete a trial within 2 months, you must complete it within 6 months, you must complete it within 1 year. The CRPC does say that as far as possible, trials must take place on a day-to-day basis, but if any of you go to any of our trial courts in Delhi, you will see how overworked these courts are. Every sessions court in Delhi has no less than 30 or 40 cases. And again, if I can flag one of the issues that I've been speaking for very long, and that's partly because many of our judicial officers, at least 30 of them, are dedicated corruption courts, and therefore courts which deal with offenses against the human body are so overworked because they have to take over the workload of these sessions judges who are marked as special courts dealing with corruption cases. So if you can have courts who have done the 2G trial for the last 4 years, just one case, imagine the load on other courts where you do so many other cases. And that's primarily the reason why it takes so long. Now, in this particular report, PLD has tracked four fast-track courts and has generally found them to be acting in a way which the law requires them to act in. And therefore, that's good. However, while I read the report, I wasn't shocked because I see this often enough, but I found that even now, while the witness is under cross-examination, the judicial officer is unable to control the kind of questioning that takes place of the rape victim for whatever reason. And this is not because the judicial officer is not sympathetic to the rape victim. In fact, the report says that in most cases they were very sympathetic, and they tried their best to make the rape victim feel comfortable within the courtroom. but the hostility she faces in cross-examination. And some of the questions are amazing, but it is not at all unusual, because we hear this all the time. At one point, the report says the defense counsel again asked the prosecutrix through the presiding officer, this time in English, at the time of penetration, did you cry with your eyes? Now, what kind of question is this? Did you cry with your eyes as though you can cry with any other part of your body? Now, this whole attempt of shaming a victim is still very, very prevalent in our courts. And it doesn't matter whether we do these trainings again and again and again, and it doesn't matter whether we have sensitive judges who are controlling proceedings, but if the defense is allowed to ask questions like this, the other so this is a major problem that rape survivors face across the country, not just Delhi, the manner in which they are cross-examined. And I don't think we've yet reached a stage where judicial officers completely take control of proceedings and say this question is disallowed, I will not allow you to ask this question, etc., etc. The other aspect of the trial stage, which this report has highlighted, is the fact that a rape survivor, when she enters a courtroom, has no clue as to what is expected of her. And therefore, there must be some process of orienting her. And very often, and I've seen this with rape survivors, they don't even understand the geography of a courtroom. They don't know who's sitting on the dais. They don't understand the concept of a public prosecutor. They don't understand the concept of defense counsels. Also, their language is very different from the language used in courts. Very often, you have illiterate witnesses who cannot give the date of incident the way it is required for recording the testimony of that witness. So we've, in fact, in the past, struggled with a witness. The incident had taken place on 8th of March, and she was unable to say 8th of March either in English or in Hindi, and so it was तीसरे महीने का 8वां दिन. It was a struggle to make her to identify the date. Now, these surely are problems that exist across the board. And so eventually, when you have a judgment, you might have the judge saying she was confused as to when the incident took place. Now, that's a very natural confusion. So I think law reforms must take into account the socio-economic reality of the country, the sort of women, and most of these women are women from, I don't think in any of these cases they were particularly literate, or they came from a particular strata of society. What is the assistance you give to this witness? How do you orient them? Do they understand the meaning of examination in chief, cross-examination, etc.? It's actually a very, very challenging task, and nobody's looked into it. So you can have all the reforms in the world, but unless you understand what is required in a court testimony, these reforms will really be of no importance. Just a little, before I end, a little conversation on these courtrooms. Now, in Delhi, we are fortunate to have these vulnerable witness courtrooms. We have them in Karkaduma, where it started. We have it in Saket courtrooms. We have it in Dwarka. And it will slowly spread to all the districts of Delhi. And it's really a very, very interesting courtroom, because it's something like this. There is a screen in between. The accused is made to sit in the ante-room. And so while he can see the proceedings in the main room, and he can even hear what is happening, there is no eye contact between the victim and the accused. But as is very rightly stated in this report, before they come to the courtroom, now, I know in the vulnerable witness courtrooms, there is a separate entrance for the witness. But even there, the report saw leakages in the system, where the defense counsel was able to go and sit with the prosecutrix in the ante-room and discuss the modalities of a compromise. Now, clearly, these are issues which we need to examine, because there is no point putting that green screen up in a courtroom and say, acha, ab no eye contact. If everywhere else there's eye contact, there is intimidation, there is threat, there is coercion, what is the point of suddenly coming into the courtroom, putting up the screen and saying, now we're not going to look at each other? So I think somewhere there the law has failed the victim, because she doesn't get that kind of assistance. Public prosecutors have a very, very important role. I find public prosecutors in Delhi now much better than what they used to be earlier. Most of them are very familiar with their cases. They take the effort to read their case files. But as Madhu rightly pointed out in her opening remarks, they do not know who their star witness is. They don't know whether she's literate, whether she's illiterate, whether she knows the sequence. So nobody's asked, see, it's a thin line. I'm a defense counsel, and I'll be the last person to say that you must chat with the victim and kind of make sure that things that she hasn't said before, she must state now, so that there's a foolproof case against the accused. But at the same time, there must be some agency that prepares her. And the prosecutor must be given the opportunity to know his witness before that very minute when the evidence starts. You know, at least they must be comfortable with each other, they must have a conversation with each other. None of that happens right now, partly because of the workload in all of these cases, and partly because there is no such system. So I think what the report says with respect to trial is interesting. I would again agree with Mrinal. Times have changed, we have progressed. A lot of courts are today very, very sensitive about what should be allowed in their courtrooms. But on a larger level, I think there are times when I feel very frustrated and I say things really haven't changed since Mathura, because the language of the courtroom is still the same. And so I think we need to work on the language inside the courtroom. We need to work towards helping the victim orient herself with the procedures in the courtroom, and as Mrinal said, with respect to compensation and other such things. So yes, we've traveled some distance, not good enough, and the situation outside Delhi, of course, is another story, maybe another report from PLD, because I do know that places like Muzaffarnagar, even the judicial officers, as sometime in 2015, 2016, told counsels for the victim that they were unaware of the changes in the law. So the 2013 law, which brought about these changes, they were unaware of those changes. So you're talking about judicial officers not aware of those changes. Imagine what that system is really, what it does to these cases. So we really need to examine the impact of the 2013 law when we go into smaller places, smaller courtrooms, smaller cities, smaller semi-rural areas, to find out how effectively this is done. As a practitioner who practices regularly in Delhi, I will say that I'm reasonably satisfied with the impact and the progress that has been made in the last couple of years. Thanks.